Good day, my name is Mark Malore. I'm with the Malore Law Firm, and I wanted to speak with you briefly today about foreclosure litigation and bringing about the foreclosure on a piece of property that you encumber as a lien holder. Whether you're a first or second lien holder, you have rights, and if the property owner is not paying you on the mortgage encumbering the property, you have rights to ensure payment or take back the property from that particular owner. I handle a lot of foreclosure litigation here and do many foreclosures, and what I find primarily with my clients in San Bernardino especially is that they're looking to foreclose on non-paying clients, but looking to do so at the least expense and with the least amount of litigation as possible to enforce their rights. I'll give you an example. I've got a set of clients who has some industrial property in San Bernardino County. They ended up trying to do the foreclosure. I think they tried to do it themselves initially before coming to see me. And what happened? There was a second on the property from some other investors who filed a lawsuit to enjoin and stop the foreclosure on the first, and they were successful in doing so. The clients hired me during the middle of that process after the litigation. A complaint was filed against them. And what was the problem there? What happened? What happened was that the first lien holder didn't follow the proper prerequisites necessary to foreclose non-judicially on a piece of property that it encumbered. And when it violated those processes, if you will, for properly foreclosing on the property, it allowed the second to hold up the sale and hold up the transaction, cost them more money in terms of litigation costs to defend the litigation, and have to restart the process all over again. So it's important to remember that if you're going to do things correctly to foreclose, you want to hire professionals that know what they're doing. What does that look like for you? Well, one thing I think it's important is to obtain a trustee sale guarantee. That guarantees through a title company that once it's foreclosed on, you're able to transfer title with no subsequent challenges to the title you're transferring. It's a free and clear title and a policy of title insurance, if you will, guaranteeing that you now have recovered title on that foreclosure sale. I always like to see my clients obtain those. It costs a little bit extra money, but you know what, in the long run it saves you money from having challenges made after the foreclosure is taken care of. Secondarily, you want to make sure the non-judicial foreclosure process is done quickly, expediently, but also done correctly. What is the non-judicial foreclosure process? Well, California has two foreclosure processes that we use, judicial and non-judicial. Judicial is what it sounds like, through the court system by use of a judge in the legal system. But non-judicial is the process that's probably allowed in your mortgage instrument, whereby once the default in payment has occurred, usually 2 or 3 months, then you record what's called a notice of default. Once the notice of default is recorded, you have to let 90 days transpire, and once 90 days is transpired, you can record what's called a notice of sale. Once the notice of sale is recorded, you can then schedule the property for foreclosure or sale on the courthouse steps, if you will, within 20 days after the notice of sale. And so it's important to make sure that process and that timeline is filed correctly. Also, what's important is to pay attention to the requirements of a notice of default and notice of sale. Whether you're dealing with commercial property or residential property, there can be different requirements for the filing of those documents. So you want to make sure you do those and use the proper forms for that, and your attorney will be able to prepare those correctly, saving you a lot of time and hassle and expense later on if they're done incorrectly, like my clients in San Bernardino. And then finally, you want to make sure that the property is foreclosed with the proper means and with the proper pricing and the proper parameters for use in foreclosure, so that the foreclosure sale can't be challenged later on by the predecessing owner or any second on the property or things like that. There's some things you waive in the non-judicial foreclosure, like recovery of the deficiency if it's a residential piece of property, but that depends obviously on whether it's commercial or residential and what type of loan was taken out. If it's residential property but it wasn't purchased to be a primary place of residence, but rather it was purchased as an investment home, All those things factor into the analysis when doing a foreclosure sale. So it's not something that you want to do alone. But those give you some just broad brushstrokes at what's all involved in a foreclosure sale, and something for you to consider if you have a particular property owner that's not paying you on the mortgage encumbering a particular piece of property. Good day.